trial.
Yes, Judge. This was reset last time to determine if the state was going to have a cooperative complainant. They indicated they have reached out and she says she is. So I guess we need a trial setting.
All right. And are these cases going to be tried together?
Yes.
All right.
And we
So,
signed a waiver.
all right. So if you all will file your joiner of the cases.
Okay.
So that
I can
you both, you're seeking to try them together and you're not going to object to that? All right. So how long do y'all expect this trial to last?
Burden of proof's on the state. I have no idea how long their case is going to be, Judge. I'd ask
Well,
them.
based upon the charge with jury selection, probably 2 days.
I was thinking 3 just in case to be on the safe side.
All right, Ms. Ferguson. Need a jury trial date, 3 days. And both of these cases will be tried together. Have you all signed an acknowledgement?
Mhm.
Okay,
We did that a couple settings ago. They've been looking for the complainant.
all right, thank you. All right, is November 18th good for you?
I'm looking, I may have a,
Let's see here. Norma, put it on the 17th. The 17th, we can do jury selection. So council, on the 17th, we'll do jury selection in the afternoon.
was just double checking. I think that. Yeah, my trial is the week, a couple weeks before.
All right.
Okay, 17th?
Yes. So what will happen is on November 17th, you need to be here. And Norma, they can be here at, put it down for 1:30. And we will have jury selection at 1:30. Your plea deadline date has expired, so the court will not accept any plea bargain agreements in this case without good cause.
We
Otherwise,
never had a plea deadline, Judge,
Ah.
because we didn't,
You
we
wanted
accelerated
your
it for
trial.
them to try and find the complainant.
but
Correct.
do you
Yeah.
want a trial and not
Yeah.
an offer?
Yes.
So no pleas in this case without good cause. Does everyone understand? Or otherwise, you'll have to plea open to the court. So if you come back on November 17th and start trial, I'm going to be expecting a trial, all right? And thank you all. You all always dress appropriately for court. I truly appreciate it.
Thank you.
All right, thank you. So once you all sign the reset form, you're excused, and I'll have you back here on November 17th, and it'll be at 1:30.
Got it.
And counsel, if there are some motions that the court needs to hear, just set it with Ms. Ferguson and we'll hear those.
Perfect. Okay.
And if the motions, if you have no objections, your clients can appear by Zoom unless it's motions involving their testimony or something.
Got it. Oh, it's legal. Yeah, it's legal.
Yes.
Yes, thank you.
All right, you're welcome. Thank you.
you.
Yes, so what will happen in that case? Normally, this is what happens when you have someone and it's co-defendants. Normally, defense attorneys are not allowed to represent both of those parties because, for example, sometimes when rubber hits the road, people will say, I didn't do it. This is the person who did it. And if they're going to have conflicting defenses, then a conflict is raised and the defense attorney has to choose who they want to represent. In this case, I asked them to file a waiver if a conflict exists, because you don't want to be in the middle of a jury trial. Then all of a sudden somebody says, oh, there's a conflict, we can't go forward. Now, of course, if something new pops up, a conflict that maybe they didn't know existed, then I'll reconsider. Jose Ramon Alvarez, if you'll come forward, please. All right.
Yes, ma'am.
Norma, recall this for September 29th. Your attorney is out.
Yes, ma'am. She's sick, I believe.
Okay. All right, so we're going to recall it back for September 29th. The coordinator will email her and she'll give you a reset form. And if some reason she is still out and we know beforehand, we'll reset it.
Yes,
But
ma'am.
for now, your recall date is September 29th.
Yes, ma'am.
All right. Thank you for dressing appropriately for court. They're going to give you a reset form. Once you sign that, you're excused.
Yes, ma'am. Thank you so much.
All right, you're welcome. Court is calling 2025 CR 009404 State versus Leslie Diane Collins. Could I have parties announced?
Megan Galloway for the state.
Robert online for Ms. Collins.
All right, this hearing was scheduled, good morning.
Good morning, Judge.
This hearing was scheduled at 9 a.m. In just one moment, let me review something.
And there are two cases, Judge.
I'm not going to call the other one because you're not the attorney of record on that case. All right, this case was scheduled at 9 a.m. It is now 9:31 a.m. The defendant has not made an appearance in the court. Deputy Laura, did you make an announcement?
Yes, sir. She is now.
All right, defense, have you had any contact with your client?
It's been a couple months, Your Honor. And I was unable to call her or reach her for today's hearing.
Okay, and let me see here. All right, state.
We're requesting a judge's warrant, Your Honor.
All right, the court will grant the state's requests and the court will issue a judge's warrant. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Have a good rest of your day.
Thank you, too, Judge.
All right, there's only a judge's warrant on that case number for that attorney. The other attorney is not present, so the court is not having a hearing on that second case yet. All right, Shelby Rodriguez. If you'll come forward, please. Hello, how are you doing?
Good morning.
All right, so your attorney is unable to appear today. So we're gonna have to recall your case. He had a medical emergency. So what we're gonna do is we're gonna recall you for September 29th. All right? For dressing up appropriately for court and showing up on time. Once you sign the reset form, you'll be excused, okay?
May I confirm, Your Honor, that's for trial?
Yes.
Thank you.
Michael Ryan Keating,
Attorney's present, Your Honor.
and where is he?
Well, he has a court order allowing him to travel, and he didn't know that this was a motion to set on a warrant that just came out last week. He was trying to get on the front side of it. He's out of town for work.
So he's not here?
He's not here. I was trying to get the state to agree to a bond so we could get him,
Can't do it.
he's got to surrender himself.
Yes.
Okay,
And because of the new laws legally, he has to be here.
okay.
All right.
Understood.
All right, Roberto Alejandro Monreal. All right, so where are we on discovery?
Judge, just recently, and I say recently, 10 days, 2 weeks ago, I got a 2 terabyte storage thing full of discovery.
Okay,
This morning, I hear there's more that just developed Friday.
This is the co-defendant to the case we had on, one of the co-defendants to the case
Mhm.
we had last week, where I let the court know that I was going to be meeting with the law enforcement agency and receiving additional discovery, which I did.
Mhm.
So I have another hard drive worth of discovery that we did not have before that I now need to tender to
And
Mr. Aguilar.
She asked me to bring I think another terabyte with the, another terabyte storage container, or
Mhm.
data storage to bring.
Mhm.
And at the same time, while this is all going on, I would like the appointment of an investigator.
okay.
I did file a motion sometime back. I have my copy.
All right, I'll sign your copy. I will tell you, if it has been tendered to me, I sign all, make sure I've reviewed everything
Okay,
and signed
okay.
everything, but just in case.
It got filed in late August. I don't know.
Oh, then that should have been signed. If
Okay.
I sign all of them, I review all of the motions and the ones that legally I can sign, I will sign them the same day I
And we
receive.
just learned that you did sign back in March, an order for a psychiatrist.
Mhm.
That interview was done, but the psychiatrist said he didn't have a copy of the order. It hadn't been entered it properly or something. And he needed to do a follow-up evaluation.
All right, so what I want you to do before you leave here, if you'll go to the back and make sure that they have the order in the system, and this is that. All right, so what we're gonna do on this is the final setting for discovery. There will be no more settings for discovery. Norma?
Yes.
And if y'all decide to go to jury trial, this trial is probably gonna end up happening perhaps in the new year. We shall see.
I was gonna say my second chair, who's not available today, is her calendar jammed all the way through. I think the last jury's possible is December 1st. And I think we got, in another case, we have that last setting.
Well, of course, this is the 187, so we'll probably be in trial, but I realize
Yeah.
Megan is smiling. But I always give the staff a long Christmas break because I know people have to shop. Now I have to shop. You know, when you have little ones and Santa comes,
And
you got to do the shopping early. You can't say I'm going to shop, you know, the day after when there's a sale because they're like, "Where's Santa?"
and there are certain people that have to prepare certain foods.
There you go. All right, so this is what I'm going to do. In state, you need to be prepared to tender an offer on this day. Norma, recall this for November 3rd. That gives everybody an entire month to look through discovery and make sure everybody has everything. And state, you'll need to be prepared to tender an offer on that day.
Yes, ma'am.
Is there anything else?
You said October 3rd,
November 3rd.
November 3rd.
Yes.
Thank you, Judge.
Now, why should I be here when it's my birth month? I have no idea.
Well, is November your birth month?
Oh, yes.
Also, can we just come back in January then?
What are you doing here?
I'm here, my leg's hurting now. Bad.
All right, can you call Amy Owen back? All right, thank you for dressing appropriately for court.
Thank you, Judge.
Thank you. Hi, Adam.
So Judge, when do you want us back?
Well, I had said the 24th.
I'm gonna
but-
follow up with my doctor on Thursday or Friday if it's not significantly better, and then
So
hopefully
if
avoiding
you
surgery.
want, Amy Owen was here. She said the 29th actually works better for her. But I told her, I know you were going on an Alaskan cruise or something.
No, I took that trip. That was a couple weeks ago. Hmm?
Oh, no, she said this week on Wednesday. So my question is, are you available for the 29th?
Yes, ma'am, I can make it the 29th.
All right, Norma, and if you'll let your client know.
I will.
All right, Norma, put that on the 29th. And we'll do jury selection on that in the afternoon. Thank you.
You.
All right, Ruby Casares. Hello, how are you doing?
I am doing good. How are you?
All right, who's your attorney?
Oh, I don't have an attorney. I'm just coming from parole to turn in paperwork to be seen by the judge to be signed.
Oh, no, that will probably need to be signed by a different judge. If you'll show the paperwork.
To her, and she'll send it
Yes, to
someone.
Ms.
Well, thank you, Judge.
You're welcome. Thank you so much.
Thank you, yeah.
And they'll let you know if you even need to be here, because you may not need to be here, okay?
Judge, I have a client, Gage Guerra. He's scheduled for today.
Mhm.
I bonded him out on December 12th, give or take some time.
Mhm.
He hasn't made a payment on the bonds or anything like that. And I've told him that he needs to make payments because I don't want the government, if I get audited, I
Mhm.
don't want the government thinking that I'm gonna pocket the money and not pay my taxes
Yeah.
and stuff. He wants me to get off the bond. He knows he'll get rearrested and he wants a court-appointed attorney.
Okay. Gage Ashton Guerra.
Your Honor, but I haven't made a motion, but I'm doing an oral motion with
Okay.
your permission.
All righty.
And if you don't, well, we'll put it on the record, I guess, when
Oh, yeah, we'll place it on the record.
Gage,
Hi, Mr. Guerra.
Hello, how you doing?
How are you doing?
I'm fine.
All right, so your attorney has told the court that he's on your bond and that you all have a contract and that you're not abiding by that contract. So when you're not abiding by contract, a bondsman is allowed to remove themselves from your bond. Do you understand?
Yes, ma'am.
All right. So here's my question. Are you going to be able to afford an attorney?
Amen.
So you're going to need one appointed to you?
Yes, ma'am.
All right. So this is what we're going to do. Once we go on the record, I'll make sure that we have those things taken care of. All right?
Yes, ma'am.
Cisneros. I'm going to allow you to withdraw from his case because he can't afford to pay you. I'm going to appoint an attorney, but with regards to your being off his bond, I'm going to need a motion filed for that.
yes, ma'am.
All right.
And Your Honor, I don't mean to be a bad person or a bad lawyer or anything like that. I just wanted on the record that I posted his bond sometime early December
Mhm.
and he only paid a little bit less than half, I believe, and he hasn't made a payment since December of last year, of course. And I've told him several times, I don't want the government thinking that I may have gotten paid in cash and I didn't deposit it and I'm not paying my taxes.
Mhm.
So I need to protect myself and that's the only reason. And the only thing I asked the court, and I'll reiterate it once I file my motion.
Mhm.
it's not to increase the bond because
Oh,
obviously.
no. Here's the thing. When bondsmen are getting off of a bond because of contract disputes, normally the court keeps the bond as it is because there has been no issue other than payment with the bond.
Yes, ma'am.
Now, if it's an issue of not reporting or something of that nature, then the court may take that in consideration. So we're going to get you another attorney. Just have a seat and then you can file to remove yourself from the bond.
Yes, ma'am. Thank you.
All
so
right.
much.
thank- All right. Ruby Caceres. If you'll come forward. All right. So let me explain to you what's going on. Now, I'm not allowed to give you legal advice,
Okay,
but based on your documents, I can tell you where you need to go. All
Okay.
right. So you want to remain in this building, but you're going to go on the second floor.
second floor.
And when you go to the second floor, and I'm going to highlight it on this form for you.
Okay.
Because it'll tell you what your suite number is. So it's suite number 217. So that's where you need to go. But you don't have a case out of this court
Okay,
because you're on parole.
okay, I
So
understand.
you don't need to come back here, all right?
I understand.
All right, so I've highlighted it. This is where you need to go. You're in the right building, but you're just on the wrong floor.
Okay,
So you want to go to the second floor,
understand.
all right?
Thank you. You have a good evening.
You too. And if you get lost somewhere on the second floor, just go into any courtroom and they'll be able to tell you where that is.
Understand. Thank you
All
again.
right, you're welcome. Bye-bye. All right. Mr. Giacorto?
Real quick, Judge, I think we had a hearing last Thursday. You wanted a location. And we so professionally wrote in a location.
I appreciate that. You know, that helps me out
Yeah,
greatly.
of course, Judge. Okay,
All right,
thank you, Judge.
You're welcome. Gilbert Gonzalez. All right, so this is a compliance hearing. So usually compliance hearings are for people who are on probation and maybe there's some issues that need to be addressed. And I'll set compliance hearings to avoid someone being revoked because sometimes people there needs to be more communication. So, and I received this supplemental report and it'll tell me what it's about. All right,
Judge, may I?
yes.
So the court received a supplemental report. The main issue with Mr. Gonzalez is he's not been available for his field visit.
Mhm.
And speaking with him this morning, just getting overall what's going on with you. He said basically his only off day is Sundays. He's been working Monday through Saturday from something like 6 a.m., 7 a.m., all the way up until 7:30, 8 o'clock p.m. in the evening. I did express to him the importance of being available for his field visits. And in addition, I went ahead and made a phone call to the field visit manager to see if they do field visits on Sundays. They do field visits on Sundays, so I'm going to request that his field visit is done on a Sunday, so that we could get this rectified. As a as a progressive sanction, his officer had him actually reporting every week
Mhm.
to her until he came to court today.
Okay.
He has reported no issues. He's not had any recent UAs that have been positive. The last one was way back in 2024. And he's been doing well. He signed up to get his GED. Classes start in December. So he's trying to make efforts to do everything that he needs to do on probation.
All right. So this is what we're going to do. You need to be there on Sundays, you understand, for your field visits.
Yes, ma'am.
So everybody's trying to work with you and they're working with you. They're going to do the field visits on Sunday. If you're not there on Sunday, we're going to have some issues. You understand?
Yes, ma'am.
So are you able to be there on Sundays?
Yes.
All right. So when the officer comes on Sundays, you need to be cooperative.
Okay.
All right.
Yes,
Is there anything else that you need help with
no,
or that have been difficult for you while you're on probation?
no.
All right, so because he's here, of course, we can stop with the weekly reporting and go back to the normal reporting schedule. And if he misses a Sunday field visit, let the court know.
Okay.
All right. All right, thank you. Thank you for addressing appropriately for court. Vashon, here's this. So anyway, I require when people are on probation that there are field visits. Field visits is just probation officers going out to the home to see what's going on. Now, the amount or the length of time I have people subject to field visits really depends on the nature of the charge. So with his charge, it was field visits until further notice. And the reason why I do that is because sometimes you think somebody's doing great on probation and they're not really doing great on probation. For example, one time we had someone who was on probation and everybody was saying, "Oh, you know, they're doing so well." And I'm like, "How are the field visits going?" They're like, "Okay, we'll do a field visit." And they did a field visit. There were drugs in the home, guns in the home, motion to revoke is filed. So, and people don't understand sometimes when they're on probation, people are like, "Oh my gosh, probation is so hard." This is rehabilitation. You're on probation because you haven't followed the rules. So that's why I do the field visits. And I know it's difficult on the probation officers and they're not paid enough, but once my saying that they have field visits monthly, then probation can do them as they see fit. And usually it's for them, they'll do a random field visits, but it's not every month. Yes, so he's saying he works, and I'm making an assumption that probation has documentation that he works. So they're able to do field visits on a Sunday. He said he will be home on a Sunday, so there should not be any issues. All right, Amanda Stephanie Ellis. All right. There should be, I should have a file for that. Because isn't this a sentencing and restitution?
Just a restitution here.
All right, could I see that, please? All right, so are you all ready to proceed?
Yes, sir.
All right, so we're set for sentencing on this, but the issue was restitution.
Yes, Your Honor.
And so is there restitution?
No, Your Honor, state did contact the complainant in this case. The complainant was told to provide receipts and the complainant failed to do so.
All right, so we're going to go on the record. The court is calling 2025 CR 007286 State versus Amanda Stephanie Ellis. Can I have parties announced?
Lauren Espinoza for the state.
Valentina Hogan on behalf of Amanda Ellis.
And are you Amanda Ellis? All right, so we're here for sentencing. The case was reset for there to be a determination of restitution. The state informed the court off the record that there was no restitution amount or proof provided by the complainant. Is that correct?
Yes, Your Honor.
So probation, the court will not order restitution in this case. All right, do you have any children?
Yes, ma'am.
What are their ages?
16 and 19.
And do they live with you?
One of them does.
Oh, and
16. 16.
are you employed?
Yes, as of right now, I haven't been working like probably the past month or so. I got hurt and then my grandma, she's in the hospital really bad right now. So I've been taking care of her there a lot. Then my daughter going back and
So how do you support yourself financially?
well, I've saved some money. And then because too, you told me that I was gonna need to, so I put some aside. And I mean, after this, I'm hoping my grandma's not gonna be in there too long and And
how far did you go in school?
I'm sorry,
How far did you go in school?
I got my diploma.
All right, so what are you planning on doing with the rest of your life employment wise?
trying
Your
to-
hopes, your dreams?
I'm trying to get back into truck driving.
Okay,
That I was doing that before and I fell off there. We had a bad accident.
so do you still have your CDL license or?
No, but I'm gonna go through all of that and stuff. Yes, ma'am.
Okay. All right, this is what the court is gonna do. And I'm sorry, state, you may be excused.
Thank you, Judge.
The court is gonna sentence you to 3 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, or you can do the patch. The patch costs more, but with the patch, they just put the patch on you, and then they give you the specific date when you need to come back, and they remove it. You do not remove it. But the patch costs more. But with regular random UAs, you have to come downtown, wait, and do your testing that way. So it's completely up to you. There's to be $1,000 fine. That will be probated. Proof of employment within 45 days. No employment as a home health care provider or with minors. There's to be no contact with Melissa Alvarez. Field visits 1 time per month for 3 months. 200 hours of community service restitution. Those hours will be deemed satisfied if you obtain your CDL license. Otherwise, you'll have to do them. You understand?
Yes, ma'am.
Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
All right, did you review the trial court certification of defendants' rights to appeal with your attorney?
Yes,
And did you understand it and sign it?
yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, you need to let your probation officer know about it. If you feel as though they're not addressing it, you can come back to the court and address it with me. Do you understand?
Yes, ma'am.
All right, once you've spoken with probation, you're excused.
Thank you.
You're welcome. Thank you. Thank you for dressing appropriately for court. So with regards to restitution, this is what I've discovered. I've discovered if you don't have restitution paid up front before someone's placed on probation, or at least half, what will end up happening is sometimes people are on probation and they never pay it back. And according to the law, if somebody is on probation and they owe restitution and they don't pay the restitution, you cannot revoke them if they cannot afford to pay restitution. So say, for example, somebody owes $2,000 in restitution and they don't pay it up front, and they're on probation and they haven't paid the restitution, and probation decides to file a motion to revoke. Well, if probation files a motion to revoke, yes, it's true, they haven't paid restitution. But if the defense were to present evidence and say, all right, this person makes, $6,000 a month. This is how much his house note is. This is how much this is. So every month he's in the negative, then you can't revoke them if they can't afford to pay. David Castro. All right, David Castro. All right, state. Have you already turned over CPS records?
Judge, I think I need an order to get them.
No, I mean, usually what will end up happening, all of their cases, they'll file a protective order and I sign it. Has that been done or no?
No, Your Honor, I do not believe it has. This is an adult sexual assault case, and so CPS records weren't ordered until after we realized they may be necessary.
All right. So do you have a motion for the court? Are you fine with the court signing the defense's motion?
If I could just have one moment to review it, Your Honor, I believe I'll be fine.
And if we didn't put a protective order on it, Judge, we don't mind doing it orally, that we won't.
Oh, no, we can write it in if it's
Okay,
not there.
okay.
But usually they have one that they can just print out immediately so you can obtain it.
Your Honor, may we step back to just confer for a moment?
Sure.
Thank you, Judge.
Are we step back, Judge?
Yes.
Thank you.
All right, if you'll just have a seat and you all let me know when you're ready.
Yes, Judge.
And while you all confer, make sure that there's no other outstanding discovery. If you all can discuss it.
Judge, I've sent her.
All right, if you'll,
I did.
Okay. Are you on John Martinez?
Correct, Your Honor.
All right, if you'll come up, please. All right, what are we here for, Mr. Martinez?
Restitution hearing, Your Honor, or at least a check-in on the, if anything had been turned in to the state for probation.
All right.
Judge, at this time, we've not received any dollar amount estimate or any documents from the complainant regarding restitution.
All right. So the court is calling 2025 CR 0000072, State versus John Anthony Martinez. Can I have parties announced?
Megan Galloway for the state.
Leo Gonzalez for John Martinez.
And are you Mr. Martinez?
Yes, Your Honor.
All right, we're here for a restitution hearing. It's the court's understanding that states you've received no documentation or information with regards to restitution.
Yes, Your Honor, the complainant in the case has been given the opportunity to be heard by the state and they have not provided any documentation or estimates to the state at this time regarding restitution.
All right, and the court will note for the record that the defendant entered a plea and was placed on probation July 21st, 2025, and it is now September 22nd, 2025. The court will order no restitution. Ms. Abrams, on John Anthony Martinez, there's to be no restitution. And we get off the record. So any issues with probation?
No, ma'am.
All right, thank you.
I thank you.
Have a good day.
Your Honor, that's all I have. Maybe excuse.
Yes.
Thank you very much.
Okay, sir,
Yes.
on Moore, does she not have a bond set in this case?
There's no bond, Judge.
All right, so, and she is in another county?
She's in custody. Well, she was when I filed that motion. She was in Travis County,
Okay,
but she's here right now. And Judge, when she was released, she didn't have an attorney. She had called, I think, your officers checking on the court date, and she never received a court date. She never received anything in the mail. So this warrant was issued on the very first court setting. She didn't have knowledge of that. So we would ask either that the bond be reinstated. I have to
well,
ask.
was she on a commercial bond or PR bond?
She was. Or if the bond could be set at 5,000, the
All right,
original amount.
so what you'll need to do, if you'll have to call the bondsman
Mhm.
and speak with the bondsman and see if the bondsman has any objection to being reinstated on the bond.
Fair enough.
Ms. Ferguson, on this case, can you see who the bondsman was and give defense the number for the bondsman?
But also in the alternative, can we get a bond set at like 5,000? That way the family could bond her out today.
Well, I mean, if you call the bondsman
Okay.
and the bondsman wants to get back on the bond and has no objection to it being reinstated, then he'll be on the bond.
Okay, I've never really seen that happen though.
All right. Oh, no, the bondsman here,
They
they've
do?
done it before.
Okay.
Yes.
All
It
right.
just depends on if she was paying them in a timely manner. Sometimes they will say yes.
Thank you, Judge.
You're welcome. And have you conferred with the state in the actual case?
Well, I talked to the state and the state's position is that the bond should be 10,000.
No. I mean, confer with
actual
them
case.
on the charges of theft of property.
Judge, I had asked for a pretrial diversion program. I had asked if this would get reduced to a misdemeanor. The state says it's so early that they need to see if it's a individual victim or if it's just a shoplifting, and they want to speak to their victim. So, yes.
All right, so if you just make sure you confer with them and look over the file, because what you're telling me, it should be in the state's file.
So the file isn't here today. And so
Oh,
I
no,
spoke-
they'll get the file down. Yes. All right, Manisha Moore. Do you remember who your bondsman was? Was it a PR bond?
County bond, and then I don't have that.
So did you use a bondsman here in Bear County or did you use one from another county? All right, so it was a PR bond.
Both sides.
All right, so if you confer with the state and they'll bring her file down.
Okay.
Thank you. Are you all ready?
Judge, yes.
All right, if you come forward. And if I have the motion,
You have my motion, I believe. Judge.
no, she has it.
Oh,
Oh, I do have it, Your Honor. I would present this one to the court. It's just the regular one that we have.
Do you want yours signed or do you have any objection? to
I
it?
don't have any objection, Judge.
All right, if your client can come up. If you'll give that to the stage so that they have it.
And with that, may I be excused, Judge?
Oh, well, you need dates.
I do need dates. Sorry.
That's okay. Let me open up his case. And state you actually have the records.
We do not, Your Honor. We have already ordered them and we are just waiting on their return.
All right, so how long is that gonna take?
Your Honor, we are following up on that request. They should have been returned already.
All right. Any other outstanding discovery other than the CPS record?
Yes, Judge.
All right, what else?
There seems to be people texting about the case, and I took screenshots and sent them to Ashley on multiple occasions. And then Officer Chavez mentioned a conversation between the complainant and Officer Martin. And it also appears from the IDR that the conversation happens between the complainant and Officer Martin at approximately 12:40 on the date of the allegation. I would like that.
So these are messages, date of the allegation?
Date of the allegation.
Okay. Any other messages?
I asked last time, Judge, for the mobile data terminal transcriptions. That shouldn't be too hard to obtain.
All right, has that been given?
No, Judge.
No, Your Honor.
Why not?
I just need to make the request to the detective.
All right, so what I can tell you all is that we were here July 22nd. And I said there was an offer due. They didn't make an offer because there was outstanding discovery. And there was a request in August, there was a request for these transcripts that he's talking about, and there appears that there's been no movement.
Yes, Your Honor. There are several officers on the case. I do believe defense is also requesting any notes that they have, any text messages. So I have sent out emails, but there are well over 30 officers on this case, and I'm trying to get all that information from.
But I
Your
mean,
Honor.
the data he wanted, the transcripts, we were here in August, he was asking for that and he hasn't had it. So has there been any requests made for it?
No, none on that, Your Honor. I was working on other parts of his request.
All right, that needs to be done.
Yes, Your Honor.
Norma, we're gonna recall this back for discovery. Recall it for that second week in October for discovery. All right, we're gonna come back on October 13th for discovery. And if there are documents that the defense has not received by that date, the next discovery date we're gonna have, all of those officers need to be here. If it's 30 officers who have information, then 30 officers are gonna need to be here to turn over the information to defense.
Thank you. Your Honor.
Yes, Your Honor.
All right.
May I
Thank you
be
for addressing
excused,
it with court. Well, once he signs the
Yeah,
reset form.
of course.
Thank you. All right, one of the biggest issues of cases moving forward is discovery. So this case, there have been discovery issues since February. And here we are in September and we're still here for discovery. And you know, I always say, I don't make the meal, right? So I don't understand what the issue is with not having discovery on certain things and indicting cases. Okay. When everybody doesn't have all the discovery.
I'm supposed to bring my client up and get a bond set so that
And once you confer with the state, do they have their file?
they don't judge.
All right, state, do you have your file on this case?
They, some reason not in the box, and I have requested them to be brought down. Our file clerk's working on it
All
right
right, so they're gonna bring the file down. Here's the thing, in this court, let me just tell you what the rule
Please
is.
tell me.
We don't put off for tomorrow what we can do today.
Judge, you're a former defense attorney, right? So I haven't been paid to wrap up everything today. So I'm just.
No, I mean, I understand what you're saying, but I want to make sure that they have all discovery, and whatever you do with your case is what you can do with your case.
They provided me electronic discovery. And so we've done that. It's just that I wanted to get back to Travis County.
We're gonna get you back to Travis. We're gonna make it happen. Raymond Haynes. Hello.
Morning, Judge.
Good morning. Where's Mr. Haynes?
He did not appear this morning.
Okay. All righty. State,
Yes, Judge.
we're gonna go on the record on Raymond Haynes. How you doing today?
Good. How about yourself?
I can't complain. It's, we're getting to the point where maybe we're about to get some fall weather, so that's always nice.
I know it is looking nicer.
Yeah.
Judge, and there is something we'd want to discuss off the record if we can.
Okay. All right, let me take care of this and then we can take care of that. Court is calling 2025 CR 007473, State versus Raymond Francis Haynes II. Could I have parties announced for the record?
Megan Galloway for the state. Jasmine Olguin for Mr. Haynes.
All right, this hearing was scheduled at 9 a.m. It is now 10:41 a.m. The court called docket. The defendant did not answer. Deputy Laura, did you make an announcement?
Yes, Your Honor, I did.
All right, defense, have you had any contact with your client?
We have been trying, Judge, and we can go off the record to discuss kind of what's going on with him. But he's not going to be appearing this
Okay.
morning.
All right, state?
We're requesting a judge's warrant, Your Honor.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider. All right, and we can go off the record. Hello. Hi, your client didn't make an appearance.
Correct, Your Honor. And I believe there was another attorney appointed prior to me on the same case. If the court felt like it was more efficient to appoint that attorney to both, I would have no objection to that. It seems like it's sort of redundant to have both of us.
Yeah, he's not here, so we'll have to wait till
Okay.
she's taken in custody. All right, the court is calling 2025 CR 009550, State versus Leslie Diane Collins. Could I have parties announced?
Megan Galloway for the state.
Brandon Lopez for Ms. Collins.
All right, this docket was scheduled at 9 a.m. The defendant has not appeared. A judge's warrant was issued and cause number 2025 CR 009404. Defense, have you had any contact with your client?
No, Your Honor.
State?
Requesting a judge's warrant, Your Honor.
All right, the court will grant the judge's warrant. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
Thank you. All right, probation, there's no applications. Court is calling 2025 CR 008393, State versus Danny Ray Williams. Could I have parties approach and announce for the record?
Lauren Espinoza for the state.
Eddie Garcia from Mr. Williams.
And are you Mr. Williams?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
The court will find that the state is in compliance with discovery. And counsel, my understanding, there are no applications?
That's correct, Judge.
All right, Mr. Williams, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Sir, did you review the court admonishments with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than a gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor. Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Williams, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Do you understand by entering this plea If you're not a US citizen, you can be deported, denied naturalization, and not allowed re-entry into the United States. Did you understand that?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 37 days in the Bexar County Jail under 1244, and there's $1,000 fine.
I think it's 500, Judge. If we agree to 1,000.
Yes, Judge, $1,000 if you could probate half.
All right, you'll have to put it as $500 since he's
I think you
doing.
did.
It's okay.
No, y'all put
Scratch it out.
probate. It should just be
Okay.
500. All right, and there's to be a $500 fine. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
Mhm.
State
Judge.
is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Thank you.
Thank you, Judge.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then how do you plead to the offense?
Yes, Your Honor.
State any evidence?
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
Objection.
Right, state, you may be excused.
Judge.
You're welcome. Did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial? A
Yes.
right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court will follow your agreement, find you guilty as previously stated, sentence you to 37 days in the Bexar County Jail under 1244, give you credit for any time served. There's a $500 fine. Time and money will run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapon or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
I am 30 years old.
All right, so you're getting close. You're not there yet. You're getting close to the point where you're going to have more of your life behind you than in front of you.
Yes, Your Honor.
If you have a drug or alcohol problem, once you're released from custody, if you can't find a place to help you with that, if I'm still here, you come back here, I'll find a place for you. But only 1 or 2 things going to end up happening if you continue this way. Either you're going to end up in and out of somebody's jail or somebody's prison, or either somebody's going to end up having to identify your body, because the last time you use may be the last time you use. You understand?
Yes, Your Honor.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome. Thank you. Rafael Rodriguez. Hello, how's it going?
Going great, Judge.
How's the Spain thing going?
It's going.
You know, whenever I see the House Hunters International, I always get the feed. You know, there was one girl on there, she said her family moved them to Thailand when she was 16, and she was upset about it because she's like, I'm in the middle of my high school. But now she loves it. She's been there, I think she said, for 15 years now.
So I have a fun fact about House Hunters.
Yes.
I had a friend who was actually on there,
Mhm.
and I didn't know this,
Mhm.
but they actually, all of those shows, the people have already
Yes.
found and bought their places, and then they film the show as if
Oh, yeah.
they're
Like
looking
it-
around.
What it always amazes me when people will say things, like, for example, people going to Sweden. I would like property in the city center. We need 3 bedrooms, 2 baths, US Western style kitchen. They'll go through all these things. Okay, how much money do you have to spend? We don't want to go over $500 a month. I'm like, good luck with that.
Try that here.
Yeah. All right. So what is happening with this case?
Judge, this is actually, I was supposed to be here last week, but I was dealing with a couple of murder trials and other
Yes.
courts. This is our first setting. Hunter and I have conferred. There's still some evidence that I need to look through. So I can't say definitively that I've gotten all the discovery because I haven't had a chance yet. So we're just asking for another conferring setting or pretrial setting so I can finish going through the evidence.
All right, Norma, I need a 45-day reset. And you all need to make sure you have discovery and state if you'll be prepared on that day to tender an offer.
Yes, ma'am.
That's it, Judge. Thank you.
All right, let me get a date. All right, November 6th, once you sign the reset form, you're excused for dressing appropriately for court.
I was cold.
Hey, we don't say that word in this court.
Last week, I was like, I gotta bring it to.
Thank you, Judge.
Thank you.
Thank you, Judge.
Deputy Laura, he's complaining about the cold in here. We don't do that.
Thank you, Judge.
Thanks. Have a good one, Hunter. Court is calling 2021 CR 7574, State versus Summer Bailey. Can I have parties announced for the record?
Megan Galloway for the state.
Actually, like Attorney Miss Bailey.
And are you Miss Bailey?
Yes, no.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
I don't understand it, but yes, I have it in my hand.
All right. So basically what that is, that's a document.
Yes, ma'am.
And that document is complaining, and I'm going to tell you in layman's term, it's complaining that you are on probation, that you're currently on probation. Do you realize you're on probation?
Yes, ma'am.
And they're saying that the conditions or instructions that the court has given you,
Yes, ma'am.
they're saying that either you didn't follow it or you violated it in
Yes,
some
ma'am.
way. So do you understand?
Yes, ma'am.
All right. Are you the same Summer Bailey who was placed on deferred adjudication in 2021 CR 7574 for the offense of aggravated assault with a deadly weapon on September 10th, 2021 for a period of 3 years and extended for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 43 on or about the 12th day of June 2025 in Bexar County, Texas. Defendant Summer D. Bailey did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant failed to attend outpatient treatment in violation of condition number 43.
How do you plead to that? True or not true?
True. I did not complete it.
All right. Did you understand by pleading true to violation of condition number 43? Court could find it true, grant the motion, sentence you to 20 years in prison and up to a
Yes, ma'am.
$10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 43?
Yes, ma'am.
Court will find violation of condition 43 true. Is there a proposed agreement?
There is, Your Honor, and just for the record, we do waive and abandon the other, or the remainders violations.
Oh, I'm
and-
so sorry. I don't have that report, but
Sorry.
No,
There's-
no, no.
There's a supplemental that.
thank you for waiving those.
And the agreement for the court's consideration is that you grant the state's motion, revoke the defendant, sentence her to 4 years TDC, and the state is going to take into consideration clause number 2025 PF 35078.
All right. Are you asking the court to follow that agreement, Miss Bailey?
Yes, ma'am.
All right. Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Summer Denise Bailey.
All right, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
I don't know how to answer that question.
All right, so.
I mean, I know what it means. I
Do
just
you
don't-
understand the question?
I understand the question. I just
Okay.
don't know how to answer it properly.
You want to speak with your attorney about that?
Really. I guess I'll waive it.
No, no, no. I don't want guessing because
I
this
know.
is very
I
serious.
know it is. I know
So,
it's very
here's the
serious,
thing.
but nobody
Do
will.
you, when you are on probation in a court, the state and the defense, they're really not allowed to have an agreement and then I have to accept their agreement. The agreement that they've reached, I don't have to accept it. I can sentence you to 20 years in prison.
Yes, ma'am.
Now you're telling me you want me to follow the agreement that you've had with your attorney and with the state. Is that correct?
And I said, yes, ma'am.
All right. So if you want me to follow that agreement, then my next question to you is, are you going to waive your right to appeal? You may want to discuss that with your defense attorney.
Yes, ma'am.
All right. So are you waiving your right
Yes,
to
ma'am.
appeal? All right. The court then is going to follow your agreement. The court is going to grant your motion. I'm sorry, grant the state's motion, find you guilty, revoke, sentence you to 4 years in the prison, give you credit for any time served. The court will request the therapeutic community. There's an affirmative finding of a deadly weapon. There's to be no contact with Richard Cantu. Take in consideration 2025 PF 35078. Is there anything else from either side with regards to sentencing?
Judge, just really briefly, it looks like she did complete safety and custody. And I believe she has 273 days credit for that.
All right, so I'll give credit for any time served for a successful completion of inpatient treatment. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you sign it?
Yes, ma'am.
All right, because this was a plea bargain agreement that you've reached, because I followed the plea bargain agreement and because you waived your right to appeal, do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So I have requested the therapeutic community for you. It doesn't increase the time that you're in custody. It's to help you with maybe if you have mental health issues, if you have drug issues, it will help you with that. When you're released from prison, if you can't find a place that can help you with that, if I'm still here, you come back here and I'll pick up the phone and call somebody to help. All right?
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you.
You're welcome. Richard Rodriguez.
We're ready, Judge. Believe the state is withdrawing their MTR, Judge.
All right. And can I see this file?
The new number one's out of Dallas. And I believe it was rejected in the
It was-
grand jury.
It was no billed by a grand jury.
Okay. And there's only one violation.
Just one
Just
violation
the one,
alleged.
but we would like to alter and amend the conditions to include an anger management class, and I believe defense counsel's in agreement with that,
Yeah, I
Correct.
as well as a no harmful or injurious contact with his significant other.
believe her name is Claudia.
Is that related to the assault that's out of Dallas?
That's my
It
understanding.
is.
All right, so the no harm or injuries, I don't do that unless the complainant is present.
Okay,
So they can appear by Zoom or in person. Because I don't know what's going on with that relationship since it's out of Dallas.
okay.
So I'll do a no contact order and then,
Well, then we wouldn't ask for it, Your Honor, because they are married, I believe, and reside together, so
Okay.
without.
Thank you.
So then just the anger management class, Your Honor.
Okay, just 1 second.
And he does reside, and I believe the probation is transferred to Dallas.
Okay. Okay, so here's the court's question. The alternate amending to include an anger management course, if the case was no bill, then why do we need an anger management course?
It's just in an abundance of caution, Your Honor, and defense counsel was in agreement with it.
Normally I wouldn't judge, but in this case, since there was no bill, my client doesn't have a problem with doing it.
All right. Ms. Abrams? On Mr. Richard Rodriguez? My understanding that his probation is actually in Dallas. Is that correct, or does he need a transfer?
Is it? Go ahead.
We would need additional permission and transfer.
So it is out of here, your probation?
It was in Dallas.
Yes, but I lived in Dallas, so that's pretty much where I've been at and been
Well,
contacted.
because you had a motion to revoke, we'll have to do another transfer back to Dallas. That's what probation is saying.
Okay, yes, ma'am.
All right, so do you have the motion?
I have the
To
NPR.
withdraw?
I have the motion.
All right, thank you.
I was just notified it was there.
All right, no problem. So, Mr. Rodriguez,
Yes, ma'am.
you are on probation.
I think till 26, Judge.
Mhm. And no, actually, you're on deferred adjudication according to this.
Yes.
So what I can tell you is the range of punishment for which you're on probation is 10 years and up to 10 years in the prison and up to a $10,000 fine. Do
Yes,
you understand?
Sean.
So you had better start moving in life as though you could potentially end up with 10 years in the prison. Do you understand?
Yes, Sean.
All right, so I'm going to sign the motion to withdraw. My understanding from both parties is that the violation of condition number one, that's been no billed. Both parties have agreed that you are to take an anger management course. So the court will order that there be an anger management course and the court will order that you're transferred to Dallas. Is there anything else you need from the court?
No, ma'am.
All right, good luck to you, okay?
Thank you, Judge.
Thank you.
You have a lovely day.
Thank you.
Should be relatively
Okay.
So in motions to revoke, number ones are really somebody has picked up a new case. And so when the case is no bill, that means that a grand jury is saying there's not enough evidence to hold them over for trial. So that's the only thing that was in the motion. So there's nothing. No. He's currently on deferred adjudication. So he's on a form of probation already. They filed a motion to revoke because they say he picked up an assault case. But in Dallas, that case was no billed. So that means it went to a grand jury. And the grand jurors heard it and they decided there wasn't enough evidence to hold him open for trial. So that's the only thing he had. And once that was no bill, they really didn't have anything. Elliot. All right, where is Elliot?
It's in custody, Your Honor.
All right, is she being brought up? All right.
Yeah,
good.
no, well, Your Honor, I just want to say that she just got evaluated for the competency on the 17th. So we're still waiting for that report.
All right, Norma. Do you have any idea when this evaluation will be completed? All right, if you'll check with her and then.
Yes, Your Honor, because usually it goes back to the magistrate and then the magistrate sends it back to this court.
Okay,
Thank you, Your Honor.
so they'll let me know.
Thank you, Your Honor.
It's on Noel Elliott. I'm sorry, counsel, I don't know why that takes so long. I think there's a shortage.
I know.
So Norma, recall this on October 28th. Yes,
Thank you, Your Honor.
you're welcome. Jonathan, Joe Anthony Thomas.
Great, Judge.
All right. All right, so what is happening on this case?
Right, we've conferred with the state this morning. He's got a new charge that just got indicted.
Hey, just one second.
Sure,
He has pending motions to revoke. Is that correct?
that's correct.
All right, can I have those files? All right, so what is happening with the motions to revoke?
We've made an offer to defense counsel. I don't think that they want to take it.
That's correct, Judge. The sole allegation in the motion to revoke is the new number one. Constantly not true to that. And so I think we're gonna have to just do a contested hearing on it.
All right, Ms. Ferguson, I need a 10-day reset for a contested hearing.
And Judge, just for the court's information, I am out from September 25th through October 5th. So my first week back will be the 6th.
October 6th,
7th is Tuesday, and I'm on the dock.
October 6th.
New 6th. That's
All
perfect, Judge. That works.
All right, Ms. Abrams. This is gonna be a contested hearing on Joe Anthony Thomas, and it's a true contested. Yes. All right,
And Judge, is that a morning docket, afternoon docket?
morning.
Morning docket. Gotcha. Thank you, Judge.
You're welcome. So what a contested hearing means on motions to revoke, it means that the defendant is saying that the allegations in the motion are not true. Sometimes they will call it a contested and it's not really contested. It's more of a true with explanation. But here's the thing about motions to revoke. The allegations in the motion, the burden of proof is different than when someone is going to a jury trial. When you have a jury trial, the burden of proof on criminal cases is proof beyond a reasonable doubt. When you have motions to revoke, it's preponderance of the evidence, more likely than not that they violated. So it's a different burden. All right, Ruben Renteria. All righty. So he only has one motion to revoke?
Yes, Judge, and then he has a new number one, or I guess not a new, but a number one and then misdemeanor cases.
All right, so what's happening on the motion to revoke?
So I've been conferring with the state judge. I believe we have come to an agreement with regards to the two felonies. We need to take care of the misdemeanor or the misdemeanors prior to, because this case is, I guess, ultimately the court follows our plea agreement that involve inpatient custody. And so I had also filed a motion for legislative continuance through October the 4th, Judge. And so depending on how you want to proceed, I don't know if you want me to urge that or if you wanted us to do the plea and come back for sentencing or how you wanted to do that.
I mean, y'all want to do it now? Everybody's here.
The only,
Otherwise, I'm going to set it for a contested.
my only question is because the agreement, if the court follows it, would entail
Him going into inpatient treatment, Your Honor.
thank you. I have,
And he has a misdemeanor evading pending that he is going to plead to as a part of the agreement. So counsel wasn't sure if you would want him to go take care of that first, or if you would want to do the plea agreement right now.
When is the misdemeanor set?
I don't have that. I was gonna go down this week and try and get that taken care of after this. But I thought the easiest thing, if the court would entertain it, would be to do the plea and then come back for, I guess, formal sentencing. I don't know if you don't do that, then
No, and let me just tell you the reason why I'm not going to do it. Y'all are telling me that obviously he has a drug issue. And would it look like if I have him plea? We don't do anything with it. He's just bouncing around free and he ends up getting a hold of some bad drugs and dies.
understood, Your Honor. Well, that wasn't the state's, that was my suggestion.
No. I'm just saying, that's why I'm not doing it. But sometimes I like people to understand why I'm not doing the things that maybe seems like that's the easy way to do. So I'm calling it back for a contested hearing.
Yes, Judge.
You all need to get whatever is happening in misdemeanor court taken care of, and we can come back on September 29th.
The only thing I would ask, Judge, is the legislative continuance is through October 4th. Any chance I could do it the week after that?
I can put it down for October 6th.
Perfect, Judge.
All right.
Thank you so much.
You're welcome, no problem. Ms. Ferguson, if you'll put this for October 6th, and it's a contested probation. On this case, they think they've worked out things, so if they have not, it'll be contested. If they have, then it won't. All right, this is my suggestion to you. Obviously, there's a drug issue going on with you. When you leave court today, after whatever happens in misdemeanor court, you need to find you somebody's AA meeting or NA meeting, and you need to be going to that daily because the last time you use may be the last time you use. Who's your support system for you?
I really have it myself and my uncle.
All right, you know, parents, no?
No, I don't.
Do you have any type of relatives for support system?
My grandparents and my uncle.
All right, so here's the thing. You do not want your grandparents or your uncles to have to come and identify your body, right? So when you leave here and you finish with your business here today, your attorney can tell you there are NA, AA meetings all around town. There are even some that you can do online. So instead of using drugs when you feel like you want to do it, go walk into an NA, AA meeting. And there are people there who will help you. You understand?
Yes, ma'am.
All right, we'll see you back on October 6th.
Thank you, Your Honor.
Thank you. And thank you for dressing appropriately for court.
Thank you.
All right, have a good one. Counsel, you may want to talk with probation and see if in the past they've tried him for felony drug court. That may be a good fit for him.
Will do,
So if
Judge.
you talk to probation now, they'll be able to let you know.
Will do. Thank you, Judge.
You're
Appreciate it.
welcome.
May I put you on?
Yes.
So, we looked into it. She's gonna do a re-referral. At first, she said that he, got rejected or would not qualify because he had a warrant, but
Mhm.
the warrant's been taken care of. So she's re-referring, doing a re-referral out. Hopefully we'll have an answer.
All right. And you may want to make sure that you talk to him about it and tell him it's a difficult program, but it's probably a better fit for him because they have a lot of support.
Will do. Thank you, Judge.
All right. Thank you.
Thank you so much.
All right. Manisha Moore. All right. Have you all had a chance to confer?
We had.
And did you get a chance to review the file?
Yes.
All right, court is calling 2025 CR 009091 State versus Manisha Moore. Could I have parties announced for the record for the state?
Melissa Alvin for the state.
Brian Bernard for the defendant.
And are you Manisha Moore?
Yes.
All right, the defendant has filed a motion requesting a bond. She was a no-show for court on September 11th. Defense, do you have any witnesses?
Yes, my client, Your Honor.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Monisha Moore,
Ms. Moore, how did you get out of jail?
PR bond.
When you was released from jail, did you communicate with the court about your next court date?
Yes, I called every day that week, and when I called someone, I'm calling no more, they send me a letter in the mail about my court day. I never got one.
So did you ever receive written notice to be in court on September the 11th?
No,
And you was, when did you become aware that you had missed your court date?
when I was arrested, when I was in jail in Travis County on the last Friday, not this Friday, but the Friday before.
And how long have you been in custody?
For like 9 days now.
And by being in custody, did it cause you to lose your job?
I'm about to lose my job. My supervisor said I have to Friday to come back.
Okay, thank you. Nothing further.
All right, any questions?
Did you give them your current address, ma'am?
Yeah, I gave them my address when I got arrested.
And is that where you returned back to when you
Yes.
got out on bond?
Yes.
Nothing further.
Oh. So, any objections to the court inquiring?
No.
So you said you were calling the court every day?
Yeah.
What court were you calling?
So the jail, I don't know, they gave me a number to call, and I gave them my case number, and they transferred me to the court. And the lady told me, don't call back no more, they'll send me a letter in the mail, and I never got a letter in the mail.
All right, so did you call this court?
I don't even know. So when I called the jail, or the courthouse, I gave them the case number. No, I don't
The
know.
187 court.
I don't even know what court I called.
Did you take the name of any person you spoke with?
No, but I can get a printout of my phone bill.
Oh, no, I'm just wondering. So state, what are you requesting?
$10,000, Your Honor.
All right, and is that based upon the fact that she did not appear?
That and the original, I saw that the original bond was $5,000.
All right. So would that change if she in fact called and said that she would send a letter? I mean, that she would receive a letter?
If she had called in,
If she had called the court and the court informed her that she would receive a letter? I don't know if this is true or not, but
Right.
would that change your opinion at all?
if she actively made an effort to try to find out and we could verify that, then yes, I would feel like she was not entirely at fault for not showing up to court.
Okay. And here's the court's other question with regards to her finances. Do you have any finances available to you? I'm sorry, any funds available to you?
I can get it from my mom, I guess.
Yeah, I mean, do
How
you
much do you have?
personally, do you have any money in your bank account?
No, I only got $194 on my books.
Okay. And state, are there any other criminal offenses
That are pending?
that are pending, or what is her criminal history?
There are none that are pending with us other than this one.
Okay.
She does have a relatively lengthy criminal history. She has convictions or adjudications for bail jumping and failing to appear, driving with license invalid, failing to ID fugitive, theft with theft under 100 with the previous conviction, and 2 theft 100 to 750s, and 2 theft 50 to 500s.
All right, just one moment. All right, this is what the court is gonna do. Counsel, I'll note that you have been present in court. Ms. Ferguson,
Yes, sir.
I need a 30-day reset on this case.
Your Honor, do you guys have afternoon dockets ever?
What date? All right, October 23rd. And we'll put that at 1:30, Ms. Ferguson.
Thank you, Judge.
You're welcome. All right, so with regards to the fact that she's previously jumped bail before, there are some new laws that are in place with regards to setting bonds when persons have previously jumped bond or absconded before while they were on bond. So I need to just do a little research. I'm aware of the law and I believe I know what legally I'm supposed to do, but I just want to double check. All right. So it'll take me 2 minutes.
Oh, I'm like, oh, my job.
Oh, no. So here's the thing. You may end up losing your job anyway, based upon what the new bond law says because of the history of bond jumping before. So I just want to review something to make sure that I'm setting it appropriately. So just give me 2 minutes, okay? DeMonte Williams. Oh, and could somebody let that attorney know? It's just that the issue is on not appearing for courts. I want to say part of the new law is you don't get a bond, but I'm trying to make sure that's the case. All right, so what is happening with this case?
Judge, so the last time that we were here, the defendant had an indicted unauthorized use of a motor vehicle, I believe. Discovery is complete in that case. However, I had to reach out to the arresting agency because there's an additional first-degree felony investigation that's stemming from that. So I did reach out to get the status. The detective that's currently investigating that first-degree felony is out. So I did reach out to the department that's investigating the case to see the status of that. So I'm waiting to hear back. And then the defendant also has an ag assault that's pending. Discovery is not quite complete on that. We're just pending a phone dump that I've requested from the detective that they are to provide me, but they have to reach out to their tech unit to obtain that and then get it to me.
Okay, so this is what I can tell you. We have other cases that are set before yours. We have murder cases, capital murder cases, sex cases that are all set before you. Your case, if you all decide to have a jury trial, it's probably going to be set in the new year. So this is what I'm going to do. I'm going to give you a November setting date so everyone can make sure that they have all of their discovery and then state at that time if you will be prepared to tender an offer.
Yes, Your Honor.
All right, Ms. Ferguson, if you can set this in November, put it for close to the last date before we have our Thanksgiving vacation.
Judge, in addition, it's not on the docket, but we have.
Just 1 second.
Oh,
Let me
I'm
get
sorry.
this. All right, November 17th. And on that date, discovery plus an offer is due. All right, yes, counsel.
Judge, we've got a motion to modify on file pertaining to GPS and requesting to modify from partial to tracking, Your Honor. I've got a copy of the motion. I did show the state and just trying to determine if the court wants to take it up or set us at a later time. The state's opposed, Judge.
State, are you ready to take this up?
I am, Your Honor.
Okay. And Norma, Williams, DeMonte Williams, he's only on one page, correct? Yeah. All righty. So the court is calling 2025 CR 010277 State versus DeMonte LaRobert Williams. Can I have parties announced?
Megan Galloway for the state.
Will Brooks for the defendant, Mr. Williams, Judge.
And are you Mr. Williams?
Yes, ma'am.
All right, your client has filed a motion requesting that bond conditions be amended. State, are you ready to proceed?
Yes, sir. This time, state is opposed for tracking, and we would ask the court that the conditions remain as they are. And at this time, we would offer B1 and B2 for purposes of this hearing.
No objections for purposes of this hearing, Judge.
All right. And I'm sorry, what were the exhibits again?
B1 and B2.
All right. States exhibits B1 and B2 are admitted without objections for purposes of this hearing only. The court has reviewed states exhibits B1 and B2. And any witnesses state other than those exhibits?
No witnesses, Your Honor.
All right, defense, any witnesses?
Just argument, Judge.
All right, the court will hear argument.
You want to hear from me
Yeah.
first, Judge? Okay. In respect to the offense reports, Judge, there are allegations at this point. We're contesting those allegations. We're going down that path. In respect to the request itself, Judge, in the motion, I've lined out a history of his supervision on this case. I believe in December, before I was appointed to Mr. Williams, there was like a zone inclusion violation. His conditions were amended at that time to full house arrest. Since that time, Judge, he's had no violation reports. His conditions of bail have been amended, I think in March of this year, to partial to allow him to attend doctor's appointments and then to work doctor's appointments in respect to a new child that he has. We're asking the court to consider tracking at this point for two reasons. One, for him to be able to care at a higher level for that child, if that makes sense, Judge. And then for employment purposes, it is difficult sometimes for certain types of jobs and employment for them to be able to provide notice in a sufficient amount of time. So for those reasons, Judge, we're asking for the alternate amendment to the tracking rather than the partial that he's currently on.
Judge, at this time we're opposed. It's the state's understanding that the defendant is currently on partial. It sounds like he does not have steady employment currently. And so given that fact, the state is opposed to tracking only based on the allegations that are contained within States Exhibit B1 and B2. We are asking that the court deny the defense's motion for tracking based on safety for the community and the complainant in each case, Your Honor.
All right, this is what the court is going to do. The court will do tracking with a curfew. So if you all can come to an agreement on the curfew, and that's what the court will do.
Sure.
All right, thank you. All right, can I see the parties back on Manisha Moore? All right, we're back on the record in 2025 CR 009091. Based upon my review of the law, it doesn't appear that you are eligible for a PR bond. If you bring me case law that says otherwise, of course, I will review it, but there have been some changes in the law, all right? And because you have that prior bail jumping in your past, I don't get a chance to know what that's about. I don't know if it was just a missed court date and you showed up the next day. The court has to go by what's in the history. You understand?
Yes, ma'am.
So I'm going to set your bond at $8,500.
Thank you, Your Honor.
All right. Is there anything else?
No, Judge.
All right, Ms. Ferguson, if you can make sure that she gets a reset form, please. State, on this bond matter, are there any no contact orders that you would like in place?
Just HEB, Your Honor, not anything with any in specific individuals.
All right, Ms. Moore. Also, that will be added, you're not to have contact with HEB.
Yes, ma'am.
All right, thank you.
Thank you, Judge. Are we
Thank you.
excused?
Once she signs the reset form.
Okay.
All right, probation, this is an application. Who's here on Baldemaro Chapa? Court is calling 2024 CR 009634, State versus Baldemaro Joseph Chapa. Can I have parties announce?
Ashley Jones for the state.
Dante Dominguez for Mr. Chapa, who is present. We are ready to proceed, Your Honor.
Are you Mr. Chapa?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, we did and signed off on the acknowledgement.
Court will find that the state is in compliance with discovery. Mr. Chapa, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on the lesser included offense of indecency with child by contact.
That is our understanding and no objections.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the range of punishment for the offense is anywhere from 2 to 20 years and up to a $10,000 fine?
Yes,
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea bargain agreement, you can be deported, not allowed re-entry, and denied naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State is proceeding on the lesser included offense. The state recommends deferred adjudication. There's to be Chapter 62 compliance. And that's a lifetime registration. There's to be no contact with the complainant and no contact with minors. Did you understand that to be a
Yes,
plea? Defense?
Yes, ma'am.
State,
Yes, Your Honor.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, were there any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years, 200 hours community service restitution, and you will be supervised by the sex offender unit. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
To the offense as charged, to the lesser offense as charged, how do you plead?
Guilty.
State any evidence.
State would offer States Exhibit 1 and all attachments.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Do you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. According to the documents, it states that all parties agree that this court has jurisdiction, that this is occurred in Bexar County. Is that correct?
Yes, ma'am.
Yes, Your Honor.
Right. So do you understand if there are allegations that did not occur in Bexar County, if it's Travis County, Harris County, or somewhere else, then this court does not have jurisdiction?
Yes, ma'am.
And are you stipulating that all of these acts occurred in Bexar County?
Yes, ma'am.
All right. Court will review States Exhibits 1 and attachments for sufficiency. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Why should I accept this?
Your Honor, Mr. Chapa, the allegation as it stands is alleged to have occurred, oh goodness, a good 2 decades ago. Since then, Mr. Chapa has had another infraction come up. The allegation as it stands was a long time ago and predates any other criminal history that he has. And we do believe that this is an appropriate resolution to this case. The victim supports it as well. It is a very old case. He has served prison time since the allegation. And he has taken part in and successfully completed the programs assigned to him by the state in that other case. So there has been, he has served a sentence. He has completed sex offender programs since that time as well. This is a very old case, and the victim does agree that this is the appropriate resolution, Your Honor.
All right, state.
That is correct, Your Honor. We have spoken with the complainant about this resolution, and she is in agreement with it and having Mr. Chapa accept responsibility for this.
All right, why is a case from 1997 only being indicted in 2024? What happened?
Well, Your Honor, there was, and the police report does include that there was an allegation made at that time that was investigated by CPS and ruled to be unfounded at that time. Since that point in time, Mr. Chapa in his criminal history does include a short prison stint after that time. It wasn't until later that the complainant brought the case back to the attention of law enforcement, who did pursue it at that time. So there is a time gap there, Your Honor.
Are you still on parole or no?
No, ma'am.
All right, the court is going to sentence you to 8 years deferred adjudication. There's a $1,500 fine that will be probated. Chapter 62 registration, no contact with the complainant. Proof of employment within 45 days, no employment as a home healthcare provider or with minors. No contact with minors. You're going to be supervised by the sex offender unit. They're requesting 200 hours of community service restitution. There's no community service that will, there's no place that will allow you to do community service. So I'm not going to order that because it would just be there.
Yes, ma'am.
And you're unable to complete that.
We appreciate the court's understanding in that. There is one issue, Your Honor. He is a resident of Harris County, and we are asking that the supervision be transferred to that county.
Right, and there'll be a transfer to Harris County. Probation, is there anything else? Is there anything else you need from the court? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and
Yes.
sign it? All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. Thank you for dressing appropriately
Thank you.
for it and continue doing what you're doing. And I know sometimes people will say that they forget to register or whatever. Do not do that.
Yeah, no, ma'am, always.
All right, and I will tell you the unit that you're going to be supervised for, there are holidays upcoming. They'll tell you what rules you need to follow based upon the holidays, okay?
Yes, ma'am.
All right, thank you.
Thank you, Judge.
With that, may I be excused, Your Honor?
Yes,
Thank you, Judge.
just let him speak with probation.
Yes, ma'am.
All right, Will, what do you have?
Judge, we came up with a curfew pursuant to the court's approval.
All
30
right.
a.m. to 9 p.m.
All right, you all didn't put the days.
I guess I should ask.
Yeah.
I was just gonna assume that.
All right, who's ready?
Matthew Garcia, B7, one down.
All right, Matthew Garcia. Hello. You know, people are dressing like it's so cold in this courtroom. Deputy Laura, are we gonna allow people to complain about the temperature in this courtroom? All right, so we're here for discovery. So where are we on that?
Your Honor, we did request we were missing the same records for one of the complainants. We did send out a subpoena for that. The state was under the impression that we would receive those records pretty quickly since we were in contact with Krista Santa Rosa, but have since failed to be able to contact them to get those records quicker than anticipated.
So when would that be here?
Your Honor, I can anticipate in the next couple weeks because we did send it out 2 weeks ago.
Yes, this is our third reset, Judge, to try to get the same records, and I know the state's been working on it, but in the span of 2 weeks, our
Yes,
third
ma'am.
reset in 2 weeks.
All right, Ms. Ferguson.
Yes.
recall this for the third week in October.
We should have it by then.
All right, we're gonna have you back on October 20th. Once you sign the reset form, you excuse. Thank you for dressing appropriately for court.
Thank you, Judge.
Thank you. Dorian Camarillo. Who's the attorney? Oh, hi, Mr. Cox, come forward. And where's Dorian Camarillo?
Went to the restaurant. Stuff.
All right.
It's just discovery.
And where are we on discovery?
Your Honor, he is the third co-defendant for that other case that we were here on earlier. So he's given me a hard drive today. So I'm
All right.
going to
And what
have
date did we give the other defendant?
November 3rd.
November?
3rd?
All right, we're gonna come back on November 3rd for discovery.
That's fine.
And I will have an offer for them, Your Honor.
Okay.
And just, okay, just where it says. Follow motion of this morning, I gave you, say the copy of it, I think you have a copy, I had to
Yeah.
amend it. He's a high school student, Judge,
Mhm.
and, we want him to, he's on, GPS monitoring,
Is he on full GPS?
full GPS. and
All right,
we-
State, do you have any objection to his being allowed to go to school?
Your Honor, we would request that he remain on full GPS, given the circumstances of the offense, and I do have a copy of the offense report.
All right, we're gonna go on the record. The court is calling 2025 CR 0060588 State versus Dorian Camarillo. Could I have parties announced?
Melissa Alvin for the state.
Cornelius Cox for the defendant.
And are you Mr. Camarillo?
Yes, ma'am.
All right, defense has filed a motion to modify bond conditions. He's asking that the defendant be placed on partial GPS. State you're objecting. Do you have any evidence?
I do. I have a copy of the offense report, Your Honor, if I may tender a state's exhibit. I marked it as 2.
All right, any
Okay.
objections? All right, the court is in receipt of state's exhibit number 2. All right, the court has reviewed state's exhibit number 2. Here's the court's question. Is the school actually going to allow him?
JJH, as part of juvenile justice academy.
Okay. All right, and what are the hours for school? Does anyone know?
Well, I think, yeah, in those, I mean, it's very strict from the JJA judge and,
All right, so what I can tell you all both is, how old are you, sir?
I'm 17.
All right, I'll allow him to go to school. I think everybody should go to school if they're supposed to be in school in high school. But you all need to let the court know what his hours are and the location of the school and what's the distance from his home to the school, because he will be given an opportunity to have the transportation time built into the hours. But that's the only thing I'm going to allow you to do. Do you understand?
Yes, ma'am.
All right, so that's what the court needs. If you all can figure out the location of the school.
I get that from
And-
mom, she's here.
All right.
Thank you.
Welcome. And here is the document so you all can fill in the times. But that's all he will be allowed to do.
Okay.
And I'm assuming he's not driving, counsel?
That's right.
All right, and add in there, no driving.
We agreed on Monday through Sunday, Judge.
Okay. All right, thank you.
Thank you, Your Honor.
You're welcome. All right, Juan Carlos Aguirre. Court is calling 2025 CR 01152. Could I have parties announced?
Your Honor, there's also the MTR.
Yeah, I'm gonna take this up first.
Can we do the MTR first?
Why are we doing the MTR first?
For purposes of the plea on the waiver and this, they're gonna be running concurrently the sentences.
I can still say it's running concurrently.
All
All
right.
right.
Sorry, Rick Payne for the state of Texas.
Donald Wilson for the defense.
And are you Mr. Aguirre?
Yes, ma'am.
Counsel, you received all discovery?
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Aguirre, did you review the waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes, ma'am.
All right, your attorney has certain rights. He has the right to have the passage of 2 days upon the presentation of the information, and he has the right of 10 days to prepare for trial And you have a right to have a grand jury hear the evidence in this case and make a decision on whether there is sufficient evidence to hold you over for trial. Do you understand?
Yes, ma'am.
By entering into a plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, freedom of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the felony information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, you're waiving the reading?
Yes, we are.
State, and you're proceeding as the information is presented?
Yes, we are, Your Honor.
Mr. Aguirre, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
By information, you're charged with assault family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
Mr. Aguirre, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen, you can be deported, not allowed re-entry, and denied naturalization?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. The state will take in consideration 2025 AL 006681 and 2025 PF 31338. And this will run concurrent with
I have the case number.
2020 CR 12202. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
There is, with the exception of, I had put restitution, should there be any, I know that he would be entitled to restitution here.
All right, it's gonna be restitution if any. Let me just tell you, if they're sending you to prison and your counsel is waiving a PSI, then whatever that restitution amount that that person claims, that's gonna be the restitution amount. And when you're up for parole, they'll take it up with parole. Do you understand?
Yes, ma'am.
All right, restitution, if any, to Anessa Nicole Guerra. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent?
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
By signing that I'm sorry, not appeal. Did you review the paragraph entitled Waiver of Appeal with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. At this time, state orders into evidence. It's Exhibit 1 with all attachments.
No objection, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendants? I'm sorry, did you review the document entitled Waiver and the Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call in, the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, was kind of a tough decision for Mr. Geary to come to, but he thinks it's in his best interest and he would ask the court to go along with the plea bargain that it's taken us quite some time to negotiate, but I think he wants to get this behind him. It's unfortunate that we've ended up here, but I think he is ready to move on and become a productive citizen once he gets this behind him.
All right, the court is going to sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Anissa Nicole Guerra. There's a $1,500 fine. State is taking in consideration 2025 AL 006681, 2025 PF 31338. And this will run concurrent with 2020 CR 12202. And there's to be no unsupervised contact with minors. Is there anything else with regards to sentencing?
No, no.
No, Your Honor.
Just that whenever we're finished with this and the MTR, we have the victim president who wishes to do victim impact statement.
Okay. All right, we're proceeding with 2020 CR 12202. Did you review the motion to enter adjudication of guilty and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Juan Carlos Aguirre Jr. who was placed on deferred adjudication in 2020 CR 12202
Yes.
for the offense of assault, family choking, strangulation on March 3rd, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation of condition number 15. On or about the 12th day of May, 2021, in Bexar County, Texas, the defendant, Juan Carlos Aguirre Jr., did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program in violation of condition number 15.
How do you plead to that? True or not true?
True. State will waive the remaining violations, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 15?
Yes, ma'am.
Court will find violation of condition 15 true. Is there a proposed agreement?
There is, Your Honor. That is to revoke the defendant's probation, adjudicate him guilty, and sentence him to 5 years TDC.
All right, so why should I give him 5 years? Because the complainant in this case is the same complainant that he has the new case on. And so why should I do this?
Judge, if we're speaking about this probation, this deferred adjudication, Mr. Geary was doing the things he was supposed to be doing at the time. He was enrolled in BIP. In fact, if you look at the records, I believe he did all but 4 classes of the BIP. But because of other circumstances, the MTR was filed on him and he did not complete it. There was some other things going on in his home life and stuff. I believe had some family health issues and stuff, but he was
he was doing the things he was supposed to be doing. He just didn't complete it because of the circumstances. So that makes him not a good candidate for probation. But I don't think to punish him in excess for something that's occurred after this probation expired is fundamentally fair on the original deferred.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years when he's been sentenced on assault family household member with a previous conviction, which means there's a previous conviction. And it's against the same complainant that he's on probation for. State, why should I give him 5 years?
It just seemed that in the best interest, considering, yes, it's the same victim, but for efficiency of judicial purposes for both cases to run concurrently together.
All right, this is what the court is going to do. The court is finding 15 true. The court is going to grant the motion, find you guilty, revoke, sentence you to $1,000 fine, time and money run concurrent. There's an affirmative finding of family violence. This will run concurrent with 2025 CR 011524. There should be no contact with Anissa Guerra. There should be no residing in a household with minors. There should be no unsupervised contact with minors, and the court is going to sentence you to 8 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
You do have a limited right to appeal. That right to appeal is that as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to start making better decisions. Otherwise, you're gonna find yourself in and out of somebody's prison. You understand?
Yes, ma'am.
And your relationship with her is over. You understand? All right, good luck to you. All right, Malik Lampkin. All right, what is happening
Judge, we've
with
been
discovery?
discovery, I think we're in a good place.
Okay.
And I think hopefully we'll be in a good place to resolve this case soon. We do have a few motions that are before the court. One is a motion to travel, and the other is a motion to amend his conditions of GPS. We did confer with the state on the motion to travel. I believe they're in agreement with the motion to travel.
Judge, we are in agreement with the motion to travel. We would just request that he check in with his pretrial and probation officer daily while he's out of town, and then a UA upon leaving and coming back, Your Honor.
They're going down to Corpus, and what they're doing down there is they're doing church retreats, Your Honor.
Okay.
And he did one previously. He didn't have an issue with that. The other thing that we are asking for is for him to be able to do mental health walks. And he previously had kind of a curfew that he.
All right, do you have any objections to mental health walks?
Judge, the way that it's stated in the motion, I do have an objection to, because it's not like a set time. It's just like whenever. I will agree to give him a period of time to take a daily walk, but not just like whenever.
So, and we were hoping that that period could be in the afternoon.
Y'all would have to confer on a period of time.
Okay.
All right, is there anything else with regards to your motions?
Nothing else, Your Honor. I'll confer in a period of time and reapproach.
All right, and then you have all of the discovery and state. Did you tender an offer?
Yes, Judge.
All right, Norma, if you can set this for a plea deadline date, late October, please. All right, October 28th will be your plea deadline date.
Thank you, Your Honor.
You're welcome. You're welcome. Keep up the good work, okay? All right.
I have a no-show today, Larry Morris. And I don't have a numbers for him or anything. I'll see if I can be excused.
Just 1 second. Did you sign it?
I did.
All right, is he up next?
No, not yet.
All right, so just give me a second. What's up next? And do not put anything else on the docket. Jeremy Duque. Are you ready to proceed?
Yes, Judge.
All right, the court is calling 2022 CR 3839 State versus Jeremy Joseph Duque. Could I have parties announced?
Megan Galloway for the state.
Brandon Lopez for Mr. Duque.
And are you Mr. Duque?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Jeremy Joseph Duque who was placed on deferred adjudication in 2022 CR 3839 for the offense of possession of a controlled substance penalty group 1 to 4 grams on October 18, 2022 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Jeremy Joseph Duque did then and there fail to report to the supervision officer as directed for the months of April, May, and June of 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And we waive and abandon the remainders, Your Honor.
Any objection?
Yeah.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is not, Your Honor. What the state is asking for is that you revoke defendant's community supervision, adjudicate him guilty, and sentence him to 3 years in prison.
All right, so I don't have a trial court certification. Was that done? It's on the wall. All right, the state is requesting 3 years. What are you asking for, counsel?
Your Honor, we're asking to follow the recommendation of probation, which was to extend for 1 year and to add state ISF cognitive track. To go into the reasoning, Your Honor, my client does not have, this is his first felony case. He has no felony conviction. He's on deferred adjudication. Currently, he's working at a jet window production factory. And he also works at American Roofing where he's starting there. So he is employed. A little bit of history on the case, Your Honor. He picked up this case in 2022. About 4 months later, he was shot. Those injuries included his chest, hand, and leg. That was part and parcel of the first MTR where he was dealing with those issues. He continues to deal with recovery of those issues. He has buckshot still in his body. He's had surgeries on his hand, and he has one lined up for his leg. That's led to some mental health issues, depression, and difficulty concentrating. We understand that there's a checklist of things that he has not completed on this probation, but my client is telling me that he understands that he has not been the most compliant, but he is dedicated to trying to keep his record without a felony and to finish his probation. I do believe that those issues from the health issues and the resulting mental health issues have been a bit of a barrier. He does believe a cognitive re-education might help him to continue to be on the outside and a productive citizen without a felony conviction.
All right, so Mr. Duque, here's the court's issue.
Yes, ma'am.
This is not your first motion to revoke. And your previous motion to revoke was you're not reporting. And we are back again for you're not reporting. I don't think you're a good candidate for probation. What the court is going to do, the court is going to grant the motion, find you guilty, revoke. The court is going to sentence you to 2 years in the prison, give you credit for any time served, and I'll request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand? All right, good luck to you when you're released from custody. If you need any help with your drug addiction or mental health, just come back to the court and I'll make sure I pick up the phone to get someone to help you. All right, thank you. All right, and Mr. Chomley, who's your client?
Morris, James Morris. Larry, sorry.
That's okay. Court is calling 2025 CR 003399 State versus Larry Morris. Can I have parties announced for the record?
Megan Galloway for the state.
Dwight Chumley for Mr. Morris.
All right, this hearing was scheduled at 9 a.m. It is now 12:27 p.m. Your client has not made an appearance, and Deputy Laura, did you make announcements?
Yes.
Have you had any contact with your client?
No, Your Honor.
All right, state your request.
Bond forfeiture or judge's warrant, Your Honor.
All right, the court is going to issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.